the thing about that case is the state did not prove him guilty. There was not sufficient evidence to prove him guilty.
Mm-hmm.
So then that's the way we decided the case.
Okay.
Then we reversed the conviction outright, which means that they couldn't try him again. We did not remand it for a new trial because we felt that this wasn't just trial error that occurred. There was no, it wasn't just evidentiary error. It was the fact that the state did not present enough evidence to prove him guilty. And if you reverse a case on that basis only, then you do not remand it for a new trial. You just reverse the conviction outright, which means that he can't be tried again.
Mm-hmm.
And that's what we did in that case. And the trial itself, was not well conducted by the defense counsel or the prosecution, in my opinion. Record reflects that. There were a lot of mistakes made during the course of the trial for the defense. And why we call that too as part of the case. And so we reversed it outright.
Okay, so in the Chicago Tribune series, Trial and Error, it mentions that you were considered the conscience of the court when you were serving as a judge. What does this mean to you?
What does this mean to me? Well, what I got from the article is what the authors of the article were saying about me, was that I was the judge on a number of decisions that changed the law in a positive way, and that I wasn't afraid to change the law if I felt that it had to be changed.
Could you maybe give an example of a law that you felt needed to be changed?
Sure. One case was People versus Payne, P-A-Y-N-E. People versus Payne was decided in 1982. When I was trying cases and when I would get cases to review on the appellate court, I noticed, and everybody noticed that was trying cases, everybody knew about it, that blacks were being excluded from the jury by prosecutors simply based on their race. This was something that was going on not just in Illinois but across the country. That if you had a black defendant or African American, I use the terms interchangeably. So if you had an African American defendant in a criminal case, mainly, but even in civil cases, in criminal cases, the prosecutor would exclude blacks from being on the jury by using what they called peremptory challenges. Peremptory challenges meant that the prosecutor had a right to exclude a person during the voir dire or when they're selecting jurors without having to state why they were excusing that person. They would just tell the judge, I want to exercise one of my peremptory challenges and I want to exclude potential juror Smith from whatever her name was, from sitting in. The judge would say, okay, that juror would be excluded. Well, invariably, if there was a black defendant, the prosecutors were just excluding all the blacks from the jury. So you had an entirely white jury convicting a black defendant in cases. And the reason, and this was, everybody knew that this was happening. The judges knew it. He saw it because the judges saw that it was happening in their own courtrooms. They did nothing about it. There was a U.S. Supreme Court case at the time that, in effect, allowed this to happen. The case was Swain versus Alabama. In that case, I think it was written U.S. Supreme Court case, written in 1962, I believe, by Justice White on the U.S. Supreme Court. And in that opinion, the court said it did not violate the Equal Protection Clause of the 14th Amendment if a prosecutor excluded people from the jury during the selection of potential jurors simply because of their race in a particular case. Unless they could show that the prosecutor did it over a series of cases. But in an individual case, the Supreme Court said it didn't violate the Equal Protection Clause of the 14th Amendment. And so they said that the prosecutors were allowed to exercise their peremptory challenges, even though they were excluding people from the jury, sitting on the jury simply because of their race. So this practice was going on all across the country. Everybody knew about it, and it was a terrible practice. At least I felt it was a terrible practice. And what it tried to do is, it used to grate me. It was so bad. It was a bad practice, and it really bothered me. Okay, so I got this case, People versus Payne, in 1982. Came up to the appellate court. I got the case, and I was assigned the case to the right to the opinion. So, in that case, the prosecutor excluded blacks from the jury simply because they were black, and the defendant was convicted.
Yeah.
So I wanted to do something if I could to stop that practice from happening. So the problem that I was faced with was this U.S. Supreme Court case that allowed this to happen. So you can't really you can't overrule the U.S. Supreme Court, and you have to follow the U.S. Supreme Court decision. So it took me months to write that opinion. It took me a long time. I was labored a long time trying to figure out how to get around that. So what I did was I decided that the case that I had was different because I was not going to look at that practice based on the 14th Amendment equal protection, but I was going to look at it as to whether or not there was a violation of the 6th Amendment of the United States Constitution, which provides that you have a right to have a jury trial of your peers.
Right.
So I said that the U.S. Supreme Court case didn't apply. So I'm deciding the case not on the 14th Amendment, but I'm deciding it on the 6th Amendment instead, and this was a violation of the 6th Amendment. And so I reversed the conviction, and that was a big case. The next day, the Sun-Times, on page 1, big title, that was the main title on the front page about the case, first time ever in the United States, first time ever in the world, really, that was ever done.
Yeah.
So what's interesting about that case is because I got a lot of criticism for that, including judges on the appellate court. After I filed the opinion, the judges on the appellate court said I was crazy. Couldn't do that. And as a matter of fact, there were 1 or 2 cases that came up to the appellate court shortly after my case, and other judges got the case, and they wouldn't follow my case. They said no, they affirmed the conviction, and they said a peremptory challenge means a peremptory challenge, and you can't do it. And they disregarded my case. And the U.S. and then the Illinois Supreme Court took the case, and they reversed it
Mm-hmm.
in a terrible opinion, in my opinion. In my opinion, the Illinois Supreme Court opinion was a terrible opinion,
Mm-hmm.
and they should have been ashamed of themselves. Not just because I was right, because there's just no way that you could defend what was going on.
Mm-hmm.
So what happened is, the Illinois Supreme Court reversed. But what happened is, the case got national attention.
Mm-hmm.
It was written up in the national law review books and stuff like that. So all of a sudden, cases across the country started percolating.
Mm-hmm.
You had cases taking the same view,
Right.
for the first time, that they actually violated the United States Constitution based on the Sixth Amendment.
Mm-hmm.
So eventually, the Supreme Court took one of those other cases.
Mm-hmm.
The case that they took was Batson versus Kentucky, or Kentucky versus Batson, B-A-T-S-O-N. 4 years later, in I guess it was, it was about 1986, I think, when
Mm-hmm.
the U.S. Supreme Court took one of those cases on that issue.
Mm-hmm.
So 4 years after I had my case decided in 1982, the U.S. Supreme Court came down with the case of Batson versus Kentucky, where they reversed their older case that they had in 1962, and they basically followed what I said in my opinion.
Mm-hmm.
As to now, what I said in my opinion was that if the trial court judge sees that that is happening, that prosecutors are excluding blacks from the jury solely because of their race, he's going to stop the conduction of the jury selection
Mm-hmm.
and ask the prosecutor, even though it's a peremptory challenge,
Mm-hmm.
you have to ask him why he was excluding that person, and he better have a valid reason. Otherwise, the judge would not allow the prosecutor to eliminate the jurors
Mhm.
like that. And the procedure that the U.S. Supreme Court said the trial judges have to follow is really a blueprint of the procedure that I said they had to follow, in my opinion. And I felt that that was the right thing to do socially, but I also felt that it made no sense for a trial judge to sit there and do nothing about something that they saw that was so wrong going on in their own courtroom. Because I always, after I filed my opinion, I attended some seminars and stuff, and the case would come up all the time, and the lawyers would ask me, how could you do that, especially prosecutors? A peremptory challenge is mean a peremptory challenge. You don't have to give excuses and all that. So my answer was, look, if a judge is sitting there in the courtroom and he sees a fight going on in his courtroom, or he sees something wrong going on in his courtroom, he stops it.
Mm-hmm.
But if he sees racial discrimination going on in his courtroom, he sits there and does nothing. That doesn't make any sense.
Mm-hmm.
So I felt that was right, and it was proven to be right. So that was a good case.
Right. So, how would you yourself define prosecutorial misconduct?
Well, the term prosecutorial misconduct defines itself, so you'd have to talk about individual cases.
Mm-hmm.
Because if you say prosecutorial misconduct, means that there's prosecutorial misconduct, that prosecutors doing something wrong.
Mm-hmm.
So whether they're hiding evidence, or whether they're not producing evidence that they're supposed to, or whether they misstate evidence, like they did in the Dreamer case that I had. Are you familiar with the Dreamer case?
I am not, no.
I had a case called Lynn Scott, People versus Lynn Scott.
Mm-hmm.
That case got national attention also. And it came a lot of